Thanks so much for attending. Today we have a very interesting topic. We had a court decision which somewhat changed asset protection in Florida and potentially some of the foreign planning that we do. And we wanted to make you aware of it and give you some background. And we wanted to start with the agenda. So we'll do an overview. Essentially, the case has to do with the idea of collecting the entity of the LLC, looking at how we reach assets associated with a judgment debtor. So it's a little bit of a technical issue, but it's extremely relevant. The process such that someone either owes money or becomes subject to a judgment in a court in Florida. What happens if they have an LLC? Can we get into the LLC? Do we get stopped from getting assets inside the LLC? There are all kinds of questions come up with respect to, is it a single member LLC? Where is it formed? How does it work? A lot of the analysis goes into that. But another issue, it's kind of a separate issue that's really raised its head over the last really 5 to 8 years is, okay, if I get a judgment against somebody who has an LLC, does it really matter if, number one, were the LLC certificates created and issued? Because there is no requirement in Florida to issue what you would think of as stock certificates. It's units in an LLC or membership interest in an LLC. And then if they were issued, where are they? And do we care? So, there's a link associated with what's happened over the last, even in the IRS issues, because there's an issue like, for instance, is cash a tangible asset? Of course, cash is not a tangible asset. I mean, but the courts have moved to this idea like, is a stock certificate a tangible asset? Well, it's a piece of paper, so it's tangible, but it's an intangible. In other words, it represents, cash used to represent this much value in gold. We got away from the gold. So a certificate represents an idea, and the idea is intangible. It's your percentage of that entity. It's a certificate. It is evidence of your percentage. Is it tangible or intangible? The piece of paper is tangible, but the idea isn't. It's a classic intangible. But what's happened over the years, that idea of defining what's tangible and intangible has been somewhat blurred, and so the courts have kind of blurred around with that. So what we're going to go through is some general background in terms of protection and LLCs, and then we're going to talk about what happens associated with a debtor who's moved the certificates in the case of here number 4, Sargeant, offshore, or in the case of the new appellate case, Supreme Court case, it's negotiable instrument offshore, or kind of converted cash to a negotiable instrument offshore. How do we get to it? Can we get to it? And Eric and I go through this all the time. That's why we're both presenting. Eric's got the background in terms of how do you get to it? And then what does it mean? And how did Sargeant come to that conclusion? And why would the new decision be totally different for the Supreme Court? The new one's a Supreme Court, though, Florida Supreme Court. So it's gonna trump everything.
Yep. Resolve the conflict.
Oh yeah, and they did. They sure did.
It was the 4th DCA, 5th DCA showdown, and the 5th DCA.
No.
They did a smackdown.
And don't be distracted. I did chip my tooth. Everyone's been asking me, what happened to? I chipped my tooth as a kid and it came up. So I'm going to get that fixed. I know I get 17 emails. This is a little overview to start the webinar. Why do we do asset protection? What's the goal of asset protection? We do asset protection to create basically assets that are not available to, after you become a debtor. So can they get into an LLC? We put assets in LLCs. We put assets in trusts. We buy assets that are not subject to collection, right? And we may do a whole combination of those things as part of an estate plan or tax planning, which is even better. So the goal is not to run away. And again, these cases show basically that if you plan and you create a structure, buy assets that are not subject to collection before there's any problems, these cases just don't come up. Both Sargeant and the new case really are, again, like most of the cases, right? They're fraudulent transfer cases.
Yeah,
essentially they're fraudulent transfer cases.
And they're debtors acting nefariously.
Yeah, they're bad
probably
actors. Yeah.
Bad actors, and putting the end first in where we land. I've been asked since this case came out. The case came as no surprise, by the way, and we shared an article that Gary and I co-authored from 2015. It was a different set of circumstances, but essentially addresses these issues. And a lot of this has to do with the timing issue. If you are ahead of the game and your timing is right, you're doing things when you need to be doing them, which is before claims and lawsuits arise. We could still do a lot of the same stuff and you still enjoy the same protections. It just so happened that Sargeant, the 2014 decision, which I candidly always thought was
it was aggressive,
was improper, created this great, really what looked like a loophole in Florida to plan around. And that doesn't exist anymore. But as you see from the article we did in 2015, that's no surprise. It's always been our thought that a judge could compel debtors to bring assets back to Florida,
so,
and they have.
Right. So we, as part of the planning, because we had Sargeant, we always suggested that stock certificates be held offshore because Sargeant says you can't get them. Right. So that case arose because someone was moving stuff around, but the case was pretty clear that with respect to the fact that assets offshore aren't really available.
And if Sargeant was a multi-member LLC instead of a corporation owned by the debtor,
oh yeah,
different set. It wouldn't matter who held the stock certificates. So the end game is that nothing really changes with respect to proper planning. The impact.
Oh, absolutely, absolutely, yeah.
And here's why. Gary will explain the difference between the corporation and the LLC.
Yeah, so we go with LLCs as opposed to corporations. Corporations have, I apologize, we have a variety of people, a huge amount of people, by the way, attending, variety of backgrounds on the webinar. But this is some basics. So people form corporations. A lot, you have people that say there's no asset protection before the LLC, or implementation of the self-settled trust. Not true. People form corporations because if you form a corporation, what the corporation does in business, as long as there's no fraud, the owners aren't liable. If you buy IBM stock, you're not liable for internal operations of IBM. The same is true if you have a small S corporation in Florida. You operate, you might incur debts, you might have somebody fall on the premises. In general, you're not liable as an owner. So that's inside asset protection. Problem with the corporation is if the owner is sued and becomes personally liable, they lose the stock. There's no reason to create a corporation because the LLC now essentially has the inside protection where if something happens inside, the owner's not liable. But if it's formed properly on the outside, if an LLC member, it's what you call an LLC owner member, is sued, the equity is not available. So you can potentially lien equity in an LLC, but it's not like a corporation where you can just take the stock. So because of that, shareholders agreements look very different from operating agreements. You can't basically lock up stock outside a corporation. You can with an LLC because if someone sues, all they can get is a lien. It comes from the partnership rules. You can see down here, before the LLC, we were delayed in Florida in implementing really a good LLC statute because it was taxed as a corporation at first for God knows what reason. And I think it was between 96 and 2000 or something like that, 96 and 99. And so what happened was the corporate bar lobbied for, well, we really need to kind of compete with this inside and outside protection. So you create, so many entities were created, limited partnerships. The problem with the limited partnership was you had a general partner that was liable for everything. So you had to work around that. It was very cumbersome. So they created this two L's. They had a limited liability partnership and a limited liability limited partnership, which exempted the general partner. Very similar to an LLC in many ways, but more complicated to deal with.
So take the Sargeant example with the stock certificate, or use that same case.
Mhm.
If I own, you mentioned IBM, I own IBM stock, and I become subject to an individual
Mhm.
claim against me, my IBM stock, assuming it's not a qualified account, retirement account, something that's exempt, is potentially exposed. Sargeant would say, well, I'll take your stock certificates and move them to another jurisdiction and make the creditor chase them. Now that goes away.
That's a
but you
great
can still
point.
put them,
Now,
you can
the-
still put the stock certificates in a trust or an LLC. He owned this company,
but it was foreign, the company.
and
but
he
that-
said
but-
the stock certificates were somewhere else.
Yeah, but so in some ways that's true. I mean, I guess that's true.
So now you put the
doesn't
stock
really
certificates
matter
in an
where the-
LLC. It's a multi-member LLC, and now there's protection. And they could be in my
Oh,
closet.
yeah. Oh, yeah, but that's interesting because I don't think that argument was raised, because it wasn't where the companies were formed. It's that the stock certificates were not in Florida.
Which is an interesting note about Sargeant, that they did, because
Yeah.
other cases they've raised that, oh, this is an Alabama corporation or an Alabama company, I have to go
Right.
to Alabama. Sargeant, they said the certificates are sitting somewhere else, and that was, I think, the position in the Buechel case as well. All right.
You mean the issue was the same?
Yeah, they had
Yeah.
the note was in Korea.
Exactly. Yeah, trusts are not, corporate entities. Basically, you're talking about something that's 500 years old, where you appoint somebody. It's the only a trustee. It's the only. Some people call it an entity. Some people call it an arrangement. I mean, I remember a trust company spending 2 weeks on a document because one side thought it was an arrangement, another side was I'm not sure it really matters. So you have a trust statute in every state, and basically in all but 18 states, if you appoint a trustee to hold assets, you have to appoint him to hold them for somebody else. If you do it properly and you appoint the trustee, depending on the trust statute, they're pretty much similar. A plaintiff suing the grantor or the beneficiary or the trustee cannot get to the assets, because it's an entity that from England, where title is divided. A lot of the people who sometimes do asset protection ask me, why exactly does a trust work like? It's because title is divided. The trustee cannot benefit from the assets, and the beneficiary cannot control the assets. So you can't get to the assets by suing the beneficiary, because the trustee controls it. You can't get to the assets by suing the trustee. It's not really the trustee's assets to enjoy. So starting with Alaska and Delaware and Nevada, basically a lot of money was going offshore because people wanted to create a trust for themselves. And that's what those jurisdictions did. I think we have 18 states now that allow you to create a trust for yourself. And if you appoint a trustee in that jurisdiction, then if someone sues you as the founder of the trust, the grantor, the statute says that the assets are not available to the plaintiff, even though it benefits yourself. It's super fascinating, and it holds up some of the time. It mostly has, we have done different seminars on it, but it mostly holds up as you create a closer nexus to that trust. So we actually have a very wealthy group now. They did in Nevada, and they're actually going to buy a residence in Nevada. I'm not sure that was totally necessary in their case, but they're going to do it. And then they have a Nevada trustee, and they're going to fund one of these trusts. Well, yesterday I was on the phone with a lawyer in Minnesota, and she asked, so exactly when does this come up? Well, it really comes up as an offshoot of the LLC, believe it or not. So an LLC in Florida or Delaware, you can own husband and wife together. And that in many ways eliminates the risk that a plaintiff of one of the two spouses will lien the equity in the LLC. because you have to have a claim against both. It's very tough unless unless husband's driving wife's car, or wife's driving husband's car, and they're both liable. It doesn't come up that much.
Spousal guarantees. I
Yeah.
always try to get my clients to avoid.
Oh, yeah.
Why franchise agreements.
And it's funny when we look, when Eric looks at one of these huge loan deals that we've done, and someone's getting sued, and the spouse isn't on it. It's amazing. Like 90%, the spouse isn't on the thing. And so they have everything tenancy by the entirety, including the LLC. So there's no lien. So if you're single, you can't do that. So we have a lot of single people. We say, well, let's create a multi-member. There may be kids, there may be nephews, but given 1% or 2% to a nephew, California already has a case, the Kirchie case already starting to look a little hard. Is that really a multi-member LLC because you gave 1% to the nephew that you see twice a year? We're not, I don't think you can bet on that at this point. So we take the founder's equity in the LLC and we put it in a self-settled asset protection trust. And a lot of them have been upheld. There have been some that have not been upheld. Typically, a bad actor.
Very technical.
Yeah.
And if you don't follow the rules,
oh yeah, very
in some
technical.
jurisdictions, Tennessee, Alaska.
Right.
By the way, Florida, there are people, I understand, attorneys who are creating self-settled trusts. Just to understand that
it doesn't work.
It doesn't work for asset protection. You may have a trust where the same person is the trustee and the beneficiary, but
irrevocable trust or not,
courts are going to ignore it.
Yeah, no doubt, that's a loser. We've gotten calls like that where
and
people.
We've got
what do you say? What do one say? It's okay if there's a corporate trustee.
If there's a corporate trustee, yes. And that's how I found out. A client came and said, "Well, a couple other attorneys said you can do this. I guess you can. But the question is, do you want it to work if it's challenged?" And it won't.
No, it won't. That's right.
We've got a couple little issues there on the next slide.
Yeah, this will be the intro.
So. You remember the Rush case? That was when he was going to put his name on the building, and then he didn't, and they sued him.
Well, he died.
And he died, but he didn't leave. He was supposed to leave money to the university.
Yeah. So Sessions died in Illinois, and he had made a promise to the medical center. That's a very nice medical center in Chicago, and he had made a promise that he was going to contribute some massive amount of money upon his death. It turned out he didn't do it, but they had relied on it. And so what happened is the heirs said, we'd rather keep the money. And the hospital said, well, we've already started on the wing. And so the court did what a lot of courts have done, which I think is very questionable. I don't know what Eric, I don't think Eric, they are the litigation people. They'll take any of these 5 different branches, and what happens is this particular argument got through, and that is that you can't create a foreign trust or a self-settled trust in a foreign jurisdiction and then get into litigation it really typically involves the government. This one didn't involve the government, and say, okay, I've got a foreign trust. I might have owed you money, but I'm not going to pay it, and you can't get it because of the foreign trust. So there's a line of bankruptcy cases. I think Lawrence is on here. There was several before Lawrence even that said where the bankruptcy court, different kind of court, much more powerful court, the bankruptcy court, but they said, what we're going to do is for public policy purposes, which used to be like, a life insurance not paying out if someone killed themselves, some crazy thing like that. That's become like the tagline. So for public policy purposes, Illinois doesn't allow self-settled asset protection trusts. And everything that happened, all the people are in Illinois, the money's in Illinois, the half-built wing on the medical centers in Illinois.
And the assets were in Illinois.
Oh yeah. And that's
the
the
real
problem,
estate and all of his assets.
Well, yeah. So
They said,
we're just applying Illinois law. No, it's not I think it was Cook Island. Yeah, Cook Islands Trust. It's Illinois, and we don't allow that. So it's not protective. So you have to be careful with the planning. I mean, we do a lot of foreign trusts, and we've never had any asset protection plan breached. But the idea is that it's a clear day. You fund the thing up. You're not trying to get away with anything. There's nothing, controversial, and they work pretty well. But when you get into this thing and you make promises or you breach something, a court's going to want to collect. And that's what we saw in Florida.
And tie this one into Sargeant and Buechel,
Yeah.
the cases we're talking about today. I want to make sure we've done to hit those, but this one is where all the assets are located in the jurisdiction, but you try to create them under a foreign entity, and we saw what happened. It didn't work, so it's almost like the exact opposite.
We have had a couple of good outcomes with foreign trusts with local assets, but really foreign trusts are made so that for instance, we have a lot of business sales. They sell their business for a lot of money. They take a little bit because they know they need the 5 to 10 million, and they put them in a foreign trust, and they have a foreign, like a Swiss group, manage the money as kind of a diversity issue, and that works really well.
Do you remember the Bilzerian? This was a family that was like, they were scammers, and they created trusts for each other. So they tried to get around the self-settled trust issue, limitations of self-settled trust. My husband created one for the wife created one for the husband, and the court looked through that one and essentially.
Well, I think they said they were going to put it.
They were going to. They were going to.
And he said, "Okay." He said, "Oh, okay. Okay. Where's the money?"
If they didn't agree to turn over assets, they were going to jail. So that was a jail.
He wasn't going to jail.
And then the Anders, that FTC Affordable Media, and Lawrence was colorful because the guy was in jail for 7 years.
Yeah, in bankruptcy, it's a crime.
So, and that was a Southern District. So that was a Florida. It was a federal case, but you're in Florida. The bankruptcy court. He had moved money after he lost. It was an arbitration at Bear Stearns, and moved
a credit
offshore. And the court said, you're going to repatriate those funds back to the U.S. and what the court called a turnover order, to turn over the funds to the possession of the bankruptcy trustee. He refused. Court said, we're going to put you in jail, kind of like the Bilzerian case. And he said, okay. And he sat in jail for 7 years. He
did recover the money.
And he sued some of his advisors, I think, too. Right?
And so did the Affordable Media.
Affordable Media, they agreed finally, after being put in jail, they agreed to execute documents appointing somebody selected by the FTC to serve as the trustee. But I think they weren't able to actually get any funds.
No, what happened was they agreed, but the reality was that the Cook Islands got completely freaked out, and because this was going to undermine the statute, they amended the statute and settled for pennies on the dollar. They actually kept the money. But the point is that the idea of a court saying that you are going to return these assets to my jurisdiction for collection is not new. It's not new, and it goes on all the time. And I actually, we do some work for some divorce lawyers, and they see it all the time, where a spouse is threatened by the court. You need to bring this back, or I'm going to put you in jail for civil contempt of court. And so it's an existing issue, and the relevance of it is that we have this first case, Sargeant. Or we're going to go into some choice of law, but that where the court decided not to do it, and that was in a Florida appellate case that's been now overturned. This is a background issue, I think, but it's a good point on this power to compel the company or individual. Which law applies?
Yeah, so we're talking about generally here, location of assets, the intangible assets versus tangible assets. How the location matters. If you set up a self-settled trust or an asset protection trust, you want to probably have your significant portion of the asset holdings controlled by a trustee in that jurisdiction, and have the assets in the jurisdiction, or at least outside of where you live. And that's work. We've defended trustees. I defended a Nevada trustee on jurisdictional issues. Court had no jurisdiction over a Nevada trustee. Case dismissed. And also when you're creating the entities, creating the trusts, figuring out where the law is going to be most advantageous. And we usually wind up in the same couple of jurisdictions.
Yeah, what's the most advantageous law? And then how do we create a connection there? Okay, and now your favorite case.
The Barber case. Yeah, this is a great case. The Barber case is this Sabrina Barber that got sued by Wells Fargo, and it was on a loan guarantee for something like $67 million. And if you're familiar with the Florida LLC Act that allows foreclosure of the single member LLC, one of the things you have to show first is that there's no reasonable chance of collection through just a charging order. So with 67 million owed and nothing being paid, the court, I think, pretty easily came to the conclusion that there was going to be no reasonable chance of prepayment. And it's interesting because in this case, she did the right thing at first. She had a homestead that would have been protected under Florida law, but then she sold the homestead. She moved money around, and she ended up moving it into a bank account that was owned by a Nevis LLC.
And to a Delaware.
I almost think she would have been better off with a bank account than another jurisdiction.
Remember, she had a homestead
That's right.
that she liquidated, which was a mistake. She
And the
probably
homestead
could
was
have kept.
totally
She
protected.
probably could have kept the homestead.
She could have taken the homestead, maybe moved some of it. She bought another homestead and taken some of those funds and put it into something that was truly exempt, like an annuity or life insurance or something.
Maybe, yeah.
Because she could have argued that it was
It
exempt
was
to
still,
exempt.
it was still exempt.
But it was too much movement. And this is what Gary had alluded to this case earlier, where the federal court looking at this issue, and this was only a year after Sargeant, and the creditors sued to try and foreclose on the LLC interest. It was a single member LLC. It was a Nevis LLC, which does not allow foreclosure of the single member, but Florida does. And because it was a Florida case with a Florida judge, Florida creditor, Florida debtor.
Yeah, same theme.
Same theme as in Rush. Everybody's here in Florida, and so we're going to use Florida law.
But what's different about that, I find what's different about the Barber is the crossover. So with trusts are weird because you have a situs and then you have applicable law. It's a little bit more amorphous. But the LLC, I mean, they were going to get to the money one way. It's a ridiculous case. But she formed a Nevis LLC and they transformed it to a Florida LLC, really without a lot of basis. I kind of thought that Barber case was aggressive and needlessly so, because it was all fraudulent transfers. She basically was going to get collected on. She moved everything into these entities. She kept everything in Florida, which is crazy. And then so it was a fraudulent transfer case.
It was a fraudulent transfer, but Gary says she transformed, which we disagree with this case.
You don't think they transformed the LLC?
No, here's the analogy.
Okay.
So you have a Nevis LLC. So
yeah.
I have a car and I title my car. I buy the car and I title the car in Montana. Back in the early 2000s. And then I drive in Florida on I-4 and driving 100 miles an hour. Cop stops to give me a ticket. And I say, hey, this is a Montana car. We don't have speed limits in Montana. Cop says, I don't care. You're in Florida. We're going to apply Florida law. You got to drive the speed limit and we're taking your car and you're going to jail. Actually on I-4, I guess.
But I find that though, but it's still a registration there and it's still like a Toyota. Like just because the Toyota Montana Toy goes into Florida, it's got to abide by the rules of the road. But I think once you create the penny, it's like that's your currency. So anyway, you could go to sleep with this, but it's fascinating because we write about this stuff all the time. You go into these courts also. By the way, the Wells thing. Our issue that we're talking about, they didn't even get to
they mentioned Sargeant.
But I mean, Sargeant they did. No, Sargeant they did. They said that the link to Sargeant, no, I mean, our issue between like the cars and how cross jurisdiction, they basically said it's like a Florida LLC and we're going to apply Florida law. But the case is a fraudulent transfer case. They could have said, she moved those assets out to avoid the creditor. We're pulling them back in and we're taking them. I thought that was kind of an easy call, but they didn't do that. But what's fascinating is it's after Sargeant, which says if your stock certificates are outside the country, we can't take them. And they said she didn't issue stock certificates.
and the court in that Sargeant case, or not Sargeant, in Barber, the court looked to an old Florida case. It's a 1953 case called Beverly Beach Properties. Inc. v. Nelson. It dealt with stock certificates. And in that case, the court said that stock interests embodied within a certificate are like, are more of a tangible asset.
That's the whole
And if they're
tangible.
not
Makes
within a
no
certificate,
sense.
they're intangible. Sargeant dealt with stock certificates, so you have to go get, and the court, instead of the court,
But the
that
court
federal court
had
saying, no,
him.
you got it wrong, the court distinguished Sargeant and said, this isn't a jurisdiction issue because we have jurisdiction because
there's no
intangible
there's no
interest attaches to the
certificate.
debtor.
But also well, let's, in Sargent, they just didn't talk about the in person. We have the debtor. They had the debtor.
Well, that's the great, they have the debtor there, and that federal court said that again, distinguished Sargeant, and one of the lines on this is because the stock certificates in Sargeant were located in Bahamas, Netherlands, Jordan, Isle of Man, and the Dominican Republic, the Florida trial court erred in compelling their turnover. But again, it's interesting that the court didn't just say, we have the authority over the debtor. We can always make the debtor do something if the debtor is in our
Yeah,
jurisdiction.
they didn't do it.
Yeah.
They didn't do it, which we always thought was kind of strange. And this is what Eric was going through in terms of the Sargent case. No jurisdiction for basically a tangible asset outside of the country, which may be true, but that's just one source of jurisdiction. If you have the debtor in your court, people think it's like a criminal action, but actually, if the judge tells you to do something, you got to do it. If you don't do it, they can put you into civil contempt. They can't put you into civil contempt forever. Ask Lawrence. They did the 7-year, but they can put you in civil contempt, and it will raise the eyebrows of everyone in the court, and that defendant's going into jail. And let me tell you, a lot of times they get the asset.
You can compel discovery production. You can compel a defendant debtor to do something. And but and I know we have a lot of we have some attorneys, some non-attorneys, and civil procedure was never my strongest suit. But let's talk about just for a moment the difference in jurisdictions. You see these words in personam. I don't know why we still use the Latin. In personam is just personal jurisdiction. So anytime a defendant is present in the jurisdiction and the court has obtained jurisdiction, the court will maintain jurisdiction, personal jurisdiction, and can order the defendant to do something. So what is in rem and quasi in rem? Quasi in rem is like it sounds. It's sort of in rem. It's like an amalgam of in rem and personal. But if you understand in rem, that will help you understand the issue. In rem jurisdiction is jurisdiction over property. So what that means is that if a court has jurisdiction over a piece of property, real property or personal property, something you can pick up and move, then the court can act on the property, including ownership and title to the property. The most common example of in rem is foreclosure actions, especially like tax deeds. I've done a lot of stuff with tax deeds, and we'll send out, you get everybody that's ever had an interest in a tax deed, you send them notice of a lawsuit, you name them in a lawsuit essentially to just establish your superiority over them for ownership purposes, for title in a tax deed foreclosure or a quiet title action. It really is what it would be. And and invariably these poor people get sued. They see their name as a defendant in a lawsuit, they freak out and they call you and say, look, we're not suing you. We don't have a claim against you personally. All we're saying is that our claim to the property is superior to your claim. And if you agree, then you don't need to respond to the lawsuit or do anything. And in quasi in rem is a mix of the two. So think of a mortgage foreclosure with a note. You have a jurisdictional issue with the property, but you also have the defendant who has title to the property. You have jurisdiction over the defendant. You're foreclosing out a defendant. And so what the court said, and what the argument that the debtor made there is that these stock certificates are in another jurisdiction, and the court doesn't have jurisdiction outside of Florida. So you can't just order that those stock certificates be returned or turned over to the creditors. The plaintiffs, the creditor, has to go to wherever those stock certificates are located and act within that jurisdiction to affect ownership and title to the stock certificates. And they turned it into this in rem type argument, a jurisdiction over the property.
Which is an option. It is an option
and it was
because
a good argument.
you register your judgment in that jurisdiction and try to collect,
Sure,
but
and
it's not the only option.
you use policy, and so you say, well, the court doesn't have jurisdiction over the property there, so judge, you can't make an order affecting the property there. We have a Foreign Judgments Act, both for domestic, in the U.S. and outside the U.S. under Chapter 55. There's a whole set of rules and statutes that apply to enforcing a judgment in another jurisdiction, and that's what the creditors need to do here. Is they need to go to that jurisdiction and go after the assets there, and the court bought it. And by the way, in that case, the plaintiffs, the creditors, I'm saying plaintiff, I think it was the creditors, they did argue to the trial court that the court had authority to compel the turnover of the stock certificates by virtue of the impersonum, the personal jurisdiction of a defendant. The plaintiffs said, judge, you've got jurisdiction over the defendant. You can tell the defendant to return the stock certificates. But the court ultimately said, no, this is an in rem jurisdiction issue. And interestingly, the court also cited to public policy and said, our public policy is that we have this, that we're not going to affect title to assets in other jurisdictions. We have this Uniform Judgments Act under Chapter 55 in it. We call it a uniform act because other states have adopted some form of that act. So if you want to go after assets in another jurisdiction, I'm not going to enter an order on those assets. I'm going to require you to go to whatever jurisdiction those assets are in and record your judgment there, go through the process of domesticating the judgment, which is a process that we
And then, of course, the certificates are gone.
and then they move. And so the court went into this policy argument, and we'll see what the fifth DCA said about the policy argument that they made, but ultimately concluded that there was no jurisdiction.
Right.
And we relied on that Sargeant case. And when you think about Sargeant and then Barber, where there was no certificates, we have you'll see earlier seminars if you pull them up
Right.
on YouTube or wherever, on our website, where we say in light of those decisions, the distinction that Barber made and how it distinguished Sargeant, at the very least, if you do, for instance, a Nevis LLC like Ms. Barber did, consider doing a Nevis LLC with membership certificates and have the membership certificates held with a manager or somebody in trust offshore in Nevis. And at least you have that argument, right? We may not always win, but at least you have the argument that, hey, you have to go to Nevis and go get those stock certificates or go get the membership certificates.
And now we have the case that said no.
Now we have Buechel in the fifth DCA, and so this was a case where this is interesting because this was really this very similar issue to Sargeant, where a party who became I think they started off as a plaintiff actually, which is kind of interesting in this case if I read the history right. And then it was either a countersuit and it was attorney's fees. So be careful what you wish for when you file lawsuits. They ended up, the plaintiff here ended up being the debtor and owing money. And there was an asset, this $4 million promissory note that was in Korea. And the creditors tried to get the court to order the defendant to bring the note back and turn it over to the creditors.
They won the case, and the defendant kind of ran away, put the money in a bank, and then that converted that deposit to like a CD, like a note. And
so then the trial court, relying on Sargeant, said that the court, the court could not enter such an order because of the jurisdiction issue, no jurisdiction over the foreign property. And then it went up to the fifth DCA on appeal. And we have the language from the case here. And there's just some good quotes out of this case. The court's citing cases from the 1990s and earlier that the court that has personal jurisdiction or in personam jurisdiction over a defendant may order the defendant to act on property as long as it's not affecting title. So the court can't enter an order. Like if you have property that's in Florida, the court can enter an order essentially issuing a certificate of title, retitling the property, notwithstanding any and we see that all the time with foreclosures, right? You get a certificate of title, and now the title is vested in a new person and under a court order, and then that person is considered the title owner.
You can't do that out of your jurisdiction.
You can't do it if it's out of jurisdiction, but you could certainly order the defendant, say, hey, you need to sign and with a negotiable instrument, with a promissory note or other negotiable instrument, you could order the defendant to endorse the instrument over to the plaintiff or deposit it with the court. And certainly we can't affect title to it if it's outside the jurisdiction, but we can tell the defendant to do it, and we can do it under a threat of contempt with jail time, as in the Lawrence case and
Right.
other cases that we've seen.
And think about the distinction. I mean, you're the plaintiff, the defendant has this CD sitting in Korea. You can just cause the court to put the defendant in jail until they bring that back and put it in your name. Whereas with Sargeant, you have to go to Korea, register your judgment. Totally different law and jurisdiction, totally different circumstances. And so you're talking about a massive expense and time during which, in many cases, the defendant can move the asset or convert it to something else. All of a sudden, it's in Japan now. So this substantially changed collection on foreign assets in terms of the asset protection side, not on the planning side, but the collection side, and in many ways clarified the law. I mean, really this case was coming. They completely obliterated it at the Supreme Court level, and I think Sargeant's kind of gone.
So there's talk in the case, remember, that Sargeant also referenced public policy. And so the Fifth DCA addressed the public policy argument. It was also addressed in the Supreme Court. And what the Fifth DCA says is Sargeant's public policy analysis is out of place. Any public policy considerations raised by Section 56.29, which is the preceding supplementary statute that you could proceed on to collect the judgment, post-judgment. Any policy considerations raised by Section 56.29 are for the legislative branch, not for a court. And they went on further to explain that you only get into public policy analysis if you're trying to interpret the language of the statute, but the language of 56.29 clearly allows a court to enter orders to compel or coerce a defendant to do something. And so that,
there's no reference to the foreign is the thing. That's why they kind of got away with it.
Maybe, yeah. And I love this one because this is the throwdown. This is like somebody at the Fifth or whatever. Somebody at the Fourth did something years ago, like in law school, to somebody at the Fifth. I don't know. But the Fifth DCA doesn't try to distinguish. Sorry, they say, so the creditor and that appealed this, and now you got the debtor, who's the appellee, who's trying to defend what the trial court did, and they're raising Sargeant, and the court doesn't even try to distinguish Sargeant. The Fifth says Sargeant is directly on point. And they further say, while Sargeant directly supports the debtor's position, we conclude it was wrongly decided. This is just like the hatchet throwdown, where the Fifth is just saying, look, we're looking at Sargeant, we agree. It's saying, facts are very similar, it's very analogous, the legal issues are directly on point, a quote right out of the case, but it was wrongly decided, so they certify the conflict with Sargeant. And then when courts certify a conflict, that means two different appellate courts have addressed the same legal issue and come to different conclusions, and now it's up to the Florida Supreme Court to decide the issue. By the way, Sargeant was appealed to the Florida Supreme Court. They declined to take it.
That's right.
But this case now is appealed to the Supreme Court, which takes us to the Supreme Court decision that just came out that I received half a dozen or so emails on. And a short, easy case to read, and it's a good case for anybody that's dealing with these issues. So what you kind of mentioned it. I've been talking for a little while. I'll get Gary's take on it.
Well, it's an interesting case because when they go back to the precedent, obviously there's a clear statute on it for the preceding supplemental, but when they go back to the cases, it's so well known that the court can require someone to act that there's essentially they go at, and the 1890 case proven by the 1850 case, and it's one of those, it looks like they're kind of grasping, but they're only grasping because this is just something that like everyone does all the time. There's no appellate law on
And
it,
that's the
basically.
weird issue. Sometimes it's, with, as, like lawyers will deal with that issue when you're trying to cite such an obvious proposition. If
Yeah.
you're writing a motion for a court, especially like in an appellate brief, and you've got to cite some kind of legal authority, but it's like, this seems pretty obvious. This is
It's
what
in the
we've always
statute.
done. This is what everybody does. How do I come up with law to cite the proposition
Because
that a contract is enforceable?
well, the court can enforce its judgment in a way that the defendant must act or fail to act to pay the judgment.
The court has the
Yeah.
power to coerce
Yeah,
the
coerce.
defendant through a threat of jail time.
Exactly.
And the court's always had that power. And I think that's the other reason the court goes back and looks at these old cases from the 1890s, is because it's a way of saying, this has always been the law. This is what we've done since the beginning of time, since before the Florida Constitution. When was the Florida Constitution?
1868.
Okay, well, maybe not before the Florida Constitution, but anyway, they look at Sargeant, they look at Buechel, and ultimately find that that Buechel was the correct way to go, and that the courts have the power to require a defendant to act on its
And I
property
think-
outside the jurisdiction.
I think the general idea that people should keep in mind with respect to the planning is that if you do have some kind of issue when you do your planning, or you're going to go into litigation, you just have to keep in mind that the court will hear your case. If you're the defendant and you lose, you just have to know that the court will take whatever action it has the power to take to enforce a judgment. The courts are not interested in you getting into a trial or a long-term litigation, someone winning and saying, nanny boo boo, I don't have anything. We can go into those cases too, the nanny boo boo cases. Not a great idea. Now, if you do your planning before and it's clear that everything's protected, you're probably in really good shape. But this idea of running around and moving stock, and when there's a judgment in place, the courts went through that litigation. They will do whatever they need to do to get to the assets. We don't know what happened in Sargeant, but that's very uncommon. Usually it's very, very plaintiff sided. So you have to do things on a clear day, well within the black letter of these protective statutes, and pick the right jurisdictions, and you'll be okay. When you start to look like you're the bad guy, that's when things go awry.
So the next slide has some other language out of this Supreme Court case. And some of these are pretty strong statements. So this again is the court saying that our power, our jurisdiction, a personal jurisdiction over the defendant, allows the trial court to coerce the defendant to act on property outside the jurisdiction. And the trial court may decree a conveyance of land situated in another jurisdiction and enforce the execution of the decree by process against the defendant. Is the court saying here that now, if I have a judgment against a defendant and I know they have property in Alabama, I don't have to go necessarily domesticate my judgment in Alabama and foreclose on the property. Maybe I could just go back to the court and ask the trial court to enter an order compelling the defendant to convey that property.
Yeah, that's
to
what's
me.
it. That's what's it.
That's pretty strong. I'd be surprised actually if a court would go that far. But it does seem that, that seems to be what the court's saying here. So this really could be a game changer for collection actions.
Yeah.
And again, the court's got power to put a defendant in jail for. We don't see that in the state court actions as much.
No.
The federal courts are the federal judges will enter
You
orders.
see in divorce,
Divorce.
the threat of bringing any asset back, putting someone in the jail. I have seen it, but it's not very common in the civil court. But you have to also keep in mind that we've dealt with cases in other states where the court won't even look at a collection action if the entity's from another state. So you have judgments everywhere. I think this is kind of a Florida thing. Now in Florida, you have to keep in mind that if you don't bring the stuff back, if it's unprotected, it's protected, you're set. But if it's unprotected and the Florida court can collect on it, you got to pretty much know that they have the power now to have the bailiff take you to jail until you give up the property and wherever.
Now, what's a simple potential solution to that is, what we do regularly in
The plan.
asset protection work with, Gary's planning. If you have that same Alabama property and that property is in an LLC, especially if there's other members, or if it's in some other, if you've held it some other way than in your own name, then at least you have the argument that you don't have control. And that's always been the prevailing argument to avoid turnover orders in the federal court, is if you do a foreign trust
Or it's not
something like that,
available.
you give up, it's not available, and we don't have any control. If the defendant truly does not have the ability, we saw that there's a case, it's Arline Grant, it's Grant v. US from
Oh, yeah.
early 2000s, and her husband owed the IRS, it was like $50 million. It's amazing, like a $50 million debt, and the IRS tried to collect from the widowed spouse after her husband died. He created foreign trusts, and the court entered some pretty severe injunction orders and other orders. It was out of the Southern District in Florida, but ultimately they weren't going to put Arline Grant in jail because the court said, all right, you got to write to the trustee, tell the trustee to
Well,
turn
she
over the
wasn't
money.
the one. Yeah.
Yeah, she didn't set up the trust.
No, but she didn't do the tax evasion either.
She didn't do that. But
Yeah.
there's been other cases where people will go and say, okay, I've asked the trustee. I think that was the
Anderson.
There's another case where they did that too. There's been a couple of them where they go and they tell the trustee, all right, and the debtor will write to the trustee and say, look, Judge, I'm sending this to the debtor. Let's get the trustee on the phone or get the manager on the phone. And they say, hey, we need to turn over property. And she says, no, we don't have authority. The trustee says, I can't do that. I don't have authority to do that.
Well, they have, the trust will be written such that they can't be compelled. So they're not, the trust does not allow the trustee to do that, even if asked by the founder.
So it can't be sloppy planning. It's got to be well thought out. Got to be good timing.
Are we done?
We got a couple.
Oh,
we got a couple more slides. We can take questions.
Yeah, if you have any questions, Tony,
click on the chat. This.
We do have a question here. Can you still convert an S corp to an LLC and retain the S election and EIN using an F org?
yeah,
reorg?
yes, no problem. No problem. And the same FEIN.
That's all the questions I have for now. If anybody else has a question, just put it into the chat box.
Here's the language on, this is again, the 5629 proceeding supplementary. This is a very useful statute. It's been amended a couple of times. Actually, it was amended in 2014, amended again in 2016. So a couple times, even from the time Sargeant was issued.
It's kind of complicated, that.
It's not, yeah, it is complicated, and everybody proceeds a different way because it's 2 pages. And so sometimes people do a new complaint, sometimes people do the notice and statute. But what's interesting is that statute does a couple of things I think are interesting. One, it gives the trial courts a lot of authority to go after debtor assets. It also contains some language that has a presumption that property that was recently in possession of the debtor that is transferred during the course of a lawsuit or within a year prior to service, and this is personal property, not real property, but property that's transferred, there's a presumption that property belongs to the debtor. You can give notices and drag in new people if you transfer properties. We've talked about that before.
It's kind of complicated, though, to integrate that with the Fraudulent Transfer Act. That's what I found. I think it becomes very confusing.
I think you use that as a vehicle, and I think we're about to do that on something that might be pretty creative. But you use that as a vehicle, and then the claim is a fraudulent transfer claim under 726. But then, here's the language on that policy. Again, the court addresses this, the 4th DCA cited policy concerns, and the Supreme Court says, that's fine when you're trying to interpret the meaning of a statute, but where the statutory language is clear, you don't need to get into policy concerns.
Let's take one more question. So can you give us your thoughts on TBE-owned LLCs in Florida, single member or multi-member?
Well, single member TBE is not available because there's only one person. So
I think what they're saying is a TBE. We've had that question before. Is a TBE considered a single member or multi-member? I think it's a multi-member.
Yeah, no. So
because it's going to be taxed like a partnership, and it's going to be
in Florida. So if you're in a community property state, you can tax it as one person.
But it won't be
We're
TBE.
not. That's true. It won't be TBE. So what is it? Multi-member? So there's no case on this. Okay, there's no case on this. And we do TBE because TBE adds a layer of protection where you need a judgment against both husband and wife to do anything. And then the question is, will you have a bad actor or a weird case like this where you have a TBE situation where it's investment assets and they haven't made a lot of distributions? So the claim, which Eric Boughman will likely make at some point if we act as plaintiff or whatever, would be, okay, you do have an LLC, it's in Florida, and you own a TBE. No one else is involved. You claim that it's a multi-member LLC, right? But essentially, you're acting as one. TBE means you don't own half; you own all of 100%. Okay, and so we can reach the assets because there are not going to be any distributions. The problem is that you also, in the same breath, have to recognize TBE. So in other words, if there's a case against only one of the spouses, you got no case. So it has to be a case where both spouses are liable, and the plaintiff's lawyer comes in and says, okay, both spouses are liable. It's a single member LLC. I'm going to get to the assets. Because if both spouses are liable and it's a multi-member, I can only lien most likely the assets. But both spouses are liable. I eliminate the TBE protection. And now it's really a single member. We haven't had that case.
And you treat it as a single member by going back. That's why it's useful to kind of look at the history of some of these. If you go back to the original, when the LLC protections began to erode, it was a 2003 case, very short bankruptcy case involving Albright, was the debtor, Ashley Albright. And that's where the court first raised this issue of, there's no innocent partner. The idea of the LLC was kind of like a partnership, so that if two partners, one became subject to a judgment, the other partner, the innocent partner, didn't have to take on the creditor as a partner. So you have the charging order, and in a single member scenario, the Albright case, and then in 2008 with Olmsted in Florida, the court said, well, we don't have an innocent partner concern because the person, it's a single member. There's no partner anyway. And then furthermore,
and that's the purpose of the charging order.
And you didn't have to get approval from another member. So yeah, the whole purpose, the policy reason behind the charging order, you'll come back to policy. The policy reason was to protect the innocent partner. So if there's no partner, you're not protecting anybody. So then we've said this before in some seminars, webinars. We saw it a little bit in that Kersey case Gary mentioned earlier. How do you begin to attack the multi-member LLC and foreclose on that interest? Well, the way you do it is you get an LLC with two bad actors. And now you can make that same no innocent partner argument.
I think remember that bankruptcy with the criminals and the vineyard? They kind of touched on that.
Cutelli.
Yeah, they kind of touched on. It's coming. I mean, it's coming because you're going to get a criminal who's got the TBE, and then they're going to chip it.
Kersey.
Yeah, that's an interesting case, but that's not TBE.
99. That was a community property. Husband is 99%. Spouse was 1%.
And that's what did it.
And the court essentially just ignored the limitations. I know we're coming. I think Tony dropped an article. Thank you for that we did in 2015 talking about this Travelers case that we cited up here. That's a case that came out after Sargeant where the debtors had property. They were being sued, and this was a pre-suit. They were being sued and had property. They moved outside the jurisdiction, cash outside the jurisdiction. And it gives you a good example of what a court can do when a court says, you know what, you're going to bring that back. You're going to deposit it with the court. And now you're in this tough spot if you represent that debtor, or if you are the debtor. What if you ignore the court and you're now looking at sitting in jail while you argue over it?
Yeah, it's a good example.
Final thoughts? I think it's 1 o'clock. If any questions on this stuff, this is kind of interesting.
Yeah, here's our contact info. You just let us know.
Reach out, contact us, further questions. You need follow-up.
Yeah, thanks so much for attending. We appreciate it. We really do.
Have a great day.